Good morning. I'm Randy Bandman, and on behalf of the Entertainment Law section of the Beverly Hills Bar Association, welcome you to our special 90-minute program, Mediating the Strikes. Can neutrals help resolve Hollywood's labor strife? Hollywood is now at a complete standstill. We are here today with our esteemed panel of entertainment law mediators and professors who will provide answers to questions raised by our moderator, Jonathan Handel, that we hope will inspire action and a path forward towards a resolution of this crisis in Hollywood. Jonathan is a transactional entertainment and technology attorney and a preeminent expert on the Hollywood unions and guilds. He's written 4 books on the guilds, has taught courses on the guilds for 12 years at UCLA, USC, and Southwestern law schools, is a Rutgers Research Fellow based on his work on residuals, was a WGA Associate Counsel and a SAG-AFTRA Outside Special Counsel, represents guilds, members, and producers, and has covered the guilds and strikes for 16 years as a journalist for The Hollywood Reporter and now for Puck News, and has appeared in the media as a commentator over 1,300 times. He's a graduate of Harvard Law School and of Harvard College with a degree in applied math and computer science. Thank you, Jonathan.
Randy, thank you very much. Thank you to the Beverly Hills Bar Association and in advance to the panelists who I'll now introduce. But thank you also for all those who are here joining us. This is an important panel. When Randy and I were trying to decide what sort of angle to take on the strikes, we realized that no one had really done a presentation focusing on the concept of mediating the strikes and trying to bring them to a amicable resolution. So that's what our panelists are going to help us explore. How can that be done? How would experienced entertainment mediators do it? Our panelists in alphabetical order are, first of all, Greg Derin, who is a mediator and arbitrator with Signature Resolution, an outside mediation and arbitration agency, a private agency, has been mediating entertainment and IP disputes for more than 20 years. He's a distinguished fellow of the International Academy of Mediators and is consistently recognized as a mediation super lawyer and a best lawyer, as well as by Who's Who Legal, as a thought leader in commercial mediation. The Hollywood Reporter called him a power mediator, and for 8 years, Greg helped teach the mediation workshop at the Harvard Negotiation Institute. He is designated as an arbitrator in the WGA basic agreement. In other words, he's one of the arbitrators from a panel who potentially gets called on to arbitrate disputes over credit, residuals, compensation, and things of that sort. Clark Freshman is a tenured professor of law and negotiation since 2007 at UC Law San Francisco, previously known as UC Hastings. And previously, Clark was at the University of Miami as a professor from 1995 to 2007. He regularly teaches lie detection, negotiation, mindfulness to leading organizations, including JAMS, which is also a private mediation and arbitration agency, DLA Piper, a law firm, Genentech, BlackRock, and the California Judges Association. As a Harvard senior, Clark negotiated, mediated, and drafted the pardon in the infamous Leo Frank case, which is now a musical. He consults on negotiation, he mediates and arbitrates worldwide. Joel Grossman is an arbitrator and mediator with JAMS, also as I mentioned, also a private mediation and arbitration agency. Before becoming a neutral, he represented the Writers Guild while at the firm Sullivan and Weiner, and was the WGA's outside counsel during the 1988 strike, 2 strikes ago, I guess. Later, he joined Sony Pictures, where he was VP for Labor Relations for 15 years and was Sony's rep in bargaining with all guilds and unions across the industry. Angela Reddock-Wright is an employment and Title IX mediator with Signature Resolution. She's been a practicing attorney for nearly 30 years and was a litigator for 15 years before becoming a mediator. Her practices included mediating and litigating claims in the entertainment industry, along with serving as a consultant to SAG-AFTRA in helping it to enhance and update its member policies and practices against sexual harassment That was in the wake of the Me Too movement. Angela has been named the best lawyer in America and is a member of the College of Labor and Employment Lawyers and the National Association of Distinguished Neutrals. She's also an adjunct professor in the Employment Mediation Clinic at USC, Gould School of Law. She's a published author and host of the radio show Legal Lens with Angela, which is on Tavis Smiley's KBLA Talk 1580. Finally, Pamela Conley Ulich is an expert on legal and business issues in the sports and entertainment industry. She has over a decade of experience teaching entertainment law classes. She's a lecturer in law at USC Gould, and she teaches deal making in the entertainment industry, and she's writing a book, A Soulful Guide to Deal Making in the Entertainment Industry, and Life, Grit, Flow, and Equanimity for All. Earlier, she was on the legal staffs of the Directors Guild and the Screen Actors Guild separately, and she served on the Malibu City Council for 8 years, including at least one term as mayor. So these are our panelists. As you can see, they've got a wide range of experience in mediation, and many of them have significant experience with the guilds. I do want to mention that you're welcome to ask questions in the chat, and Randy will be sending those over to me as they arise. So feel free to ask questions throughout the session, and we will take additional questions at the end, time permitting. This is a jam-packed session. That's why we've scheduled it for 90 minutes. And exactly how long it'll run, we'll find out. Let's start with a fundamental question. Not everyone here is a lawyer, and not everyone here has ever been involved in mediation. So what is mediation? Greg, do you want to kick us off with that?
Sure. As you said, I don't know exactly what the background of everyone who's viewing this is, but I would venture a guess that almost everybody who's watching has mediated at some point in their lives. We negotiate with everybody in our lives, whether it's our parents, our children, our spouses, in our professional lives. A mediation, simply put, is a facilitated negotiation. You have a third party who is impartial with regard to the parties to the dispute and to the subject matter of the dispute, who helps facilitate the negotiation and helps the parties try to reach a resolution. The mediation itself is a consensual process. The parties have to agree to engage in the negotiation. They have to agree to the impartial person serving as the facilitator, and there are several keys to a mediation itself. One is that it is non-binding. The parties engage in a process of self-determination to reach a resolution. If they like a deal, they take it. They don't like a deal, they don't take it. Another that in a classic mediation that makes it extremely powerful is that it is generally a confidential process. And when the parties agree to keep what goes on in the mediation confidential, it encourages two things. One is the exchange of information, the creation of a certain level of information symmetry, so that the parties really can negotiate on common ground. But it also encourages the parties to be much more candid with one another than they often are, for example, in a classic litigation matter, when they're not sharing information, or they're not being as forthright as they might be, when they might wind up being deposed and asked questions about what they say during the negotiation. There's a lot more I can talk about in terms of the mechanics of it, the timing of it, about who may be the mediator, but I think in a nutshell, that's what a mediation is, and we'll get into some of those mechanics later.
Right. So concretely, it could be as informal as you have a dispute between a parent and a child, and the uncle mediates, intermediates perhaps, and tries to bridge the gap and reduce the tension. Or it could be as formal as as one of you folks being retained and paid, usually 50-50 by the parties, to help mediate a dispute that is tending towards litigation, or even is in early stages of litigation.
And it could, Jonathan, involve two parties, or it could involve hundreds of parties in some kind of massive litigation that involves hundreds and hundreds of millions of dollars. Or, you know, very early on in my mediation, I've been doing it over 20 years, but very early on, you know, the opening demand was $1 billion. So you know,
And that was a parent-child mediation.
well, some of the most emotional mediations involve very small amounts of money, ironically. So,
yeah,
right.
The less at stake, the more at stake. Does anyone else want to add to that definition? We will get into the mechanics and tools and techniques later, but does anyone else have anything to add to Greg's summary?
I'd like to add, I grew up as the middle of 3 sons in my family, and without realizing it, I was mediating between my 2 brothers ever since I was a kid. And so just second what Greg said, that everybody experiences mediation in one aspect or another. I just wanted to add that it's really crucial in any mediation for both sides to have confidence that the mediator is neutral. If there's any showing at all that the mediator is typically on one side or on the other side, and somebody feels that the mediator really has something to do with the other side, the mediator will be unsuccessful in every sense. So we are neutral. We have reputations built on our neutrality. And I certainly think if we want to apply later on in this session the techniques of mediation to the strike, that's going to be absolutely critical, that there's complete comfort on both sides of any discussion of the neutrality of the person who's acting as a go-between or a mediator.
Great. Go ahead.
And I think one thing important with respect to these strikes that are happening right now, a mediator not only has to be objective, but in my humble opinion, it has to be somebody who is respected by both sides. So objective and respected because of their knowledge. I know we can discuss this later about the role of the mediator, but in my opinion, it should be an intermediary, not a mediator.
Which is a form of mediation, but not but in another variant. And we will definitely get into that. And that's a good lead in to let me and some of the panelists help set the stage as to what the negotiation process looks like in collective bargaining, because although a lot of people on this call will be familiar, at least, will be familiar with arguments between 2 brothers, and will be familiar in general with a litigation concept, 2 parties suing each other or about to, and you want to mediate that. What does collective bargaining look like in the entertainment industry in particular? It is conducted in a room in Sherman Oaks, in the Sherman Oaks Galleria. There is a small office building there where the AMPTP, the Alliance of Motion Picture and Television Producers, which is actually the Studio and Streamer Alliance, 8 companies that are negotiating parties, and then everyone else, when an agreement is reached, becomes other producers and studios become signatories to the agreement. But there are 8 negotiating parties, labor VPs such as Joel served as for Sony, and staff of the AMPTP, headed up by Carol Lombardini, the president of the organization. There are 100 or more people in the room, because then, for example, the SAG-AFTRA negotiating committee is about 80 people. The DGA committee, they reached a deal, was about 80 people. And then you've got staffers from the union as well, both the top staff and support, and several levels of executives and support staff. And likewise, there'll be labor VPs at different levels from the studios. So it's a very large room. What goes on in those massive sessions has a lot of elements of kabuki theater. People kind of lecture at each other. They talk. They speechify, and then they sometimes will break out into caucuses, which is where each side goes into its own room and talks internally. But the real deal making gets done in what are called sidebars, where 2 to 4 people, basically, the top negotiator and maybe a deputy from each side, meet separately and get into a discussion of, okay, what is your bottom line here? I mean, look, we can move a little, but you've got to move a little. How are we going to close on this issue, whether it's the increase in basic wages or residuals thing or whatever. And that's where the deal making gets done. The AMPTP operates on the basis of unanimity. So you've got to get all the companies on the same page. The companies are much more divergent in their interests now than they used to be. You've got 3 pure play streamers. You've got 3 companies that own major broadcast networks. You've got other companies that are, Warner Discovery is heavily into reality. Sony is a supplier of television, but doesn't have a network. So unlike 15 years ago, when the companies were more congruent, it's potentially harder to get them all on the same page. SAG-AFTRA's negotiating committee in the past has operated on the basis of majority, but I'm informed by a union side source that they are operating on the basis of unanimity also this year. So you've got different subgroups of interest, singers, dancers, background performers, principal performers, people who do more TV, people who do more features, people who earn a fair amount, people who don't earn a fair amount, all of that. And you've got to bring them together as well. And we will talk a bit later about the, at least an outline about the challenges of that. I'd like to ask Joel to supplement my my discussion, and then Pamela to talk a little bit about some of the chief negotiators. Joel, you've been in the room more often than any of us, primarily in your capacity at Sony. What can you tell us?
Yeah, well, Jonathan, you hit it on the head when you said that there can be very large meetings with the entire negotiating team of the studios, which be representatives, more than one, maybe 2 or 3 from each studio, and then a whole bunch of folks from whichever guild is negotiating. That is not the place where deals get made. That is the place, as you said, where people give speeches, explain their demands, try to be polite, but that is not the place where any deal can get made. Each side will caucus with their leading representative. We have, for example, when I was negotiating, the late Nick Counter was the chief negotiator for the studios. Carol Lombardini, who is now the chief negotiator, was Nick's number 2. And we would have a caucus with representatives of the studio and Nick. We would try to give him some instruction as to what we wanted, what worked for us, what didn't work for us. And Nick would then go into a sidebar with whoever was representing the given union, and that would be just a small team. And Carol would be with him taking notes, and Carol also was a wonderful writer, as she had to write out in contract language what happens. But that would be the place where the deal gets made in the sidebar. Then Nick would come back to the big caucus of all the studios. The representatives of the guilds would go back to their people, try to get ratification, which sometimes, is difficult. But as you said, the rule of unanimity certainly applied in the studios, and I think more or less for the guilds as well. So once we all accepted whatever sidebar decision had been made, we were able to then put everything in contract language. But it is a very long process, lots of days and lots of late nights for people to try to come up with ideas that would work.
And Pamela, do you want to talk a little bit about the current chief negotiators and what you know about them?
Yeah, and I think I like what you said about where it's supposedly taking place, which is it's in Sherman Oaks at the AMPTP offices. But let's face it, right now, to kind of borrow from Barbie, they're at the beach. Let's meet at the Malibu beach. That's where they're at right now. They're not in Sherman Oaks.
That's right.
And I think it's important to look not just where they are, should or can meet, but who are the major players, like Joel said. Who's the new Nick Counter? It's Carol Lombardini. She's a seasoned negotiator. She's been there 40 years at the AMPTP this July. So she has a lot of skills. In my class, we interviewed her for the deal-making class about what are the top skills for deal makers. And I think it's important to kind of leave some breadcrumbs for the guilds who may or may not be watching this. But she really looks at these qualities: integrity, flexibility, tenacity, being well prepared, creative, resilient, and patient. Now let's look at the guilds. with respect to SAG-AFTRA, you have a negotiator. The top negotiator is Duncan Crabtree Ireland. He has been at the Screen Actors Guild since 2000. He was promoted to the NED for the chief negotiating position in 2019, I believe. So he's relatively new and then was reappointed in May 2021. You have, on the one side, you have Duncan and Carol as the chief negotiators for SAG-AFTRA. On the other side, with the respect to the Writers Guild, it's a relatively new person in charge, which is Ellen Stutzman. I don't know a lot about her, but I think it's important to know who, not only where they're going to be, but who the players are. And that's what, to the extent of my knowledge.
Yeah, Ellen's been at the Writers Guild for, I think, 15 years or so, but as you said, is newly promoted to the role of chief negotiator. David Young, the executive director, is out on medical leave. That was a sudden announcement right just days before the Writers Guild negotiations started. That was very surprising to people. We'll talk about the role of, well, why don't we just ask, does anyone else have thoughts about the role of personalities and personality types in as it relates to negotiation and mediation? Maybe Clark, you want to jump in on that, or Angela?
Yeah, I think there are a lot of different mediator types that do well, and so people have different approaches. I think one thing that can be very helpful is lightheartedness or humor. We often focus on negativity and sort of how mediators have to deal with negative emotions and clamp down on those. But there's a lot of academic research and practical experience that creating a positive environment, confidentiality, as was mentioned, is really important. But part of the environment that's necessary is a certain amount of trust. And positivity can be related to people being able to be forgiving, right? Somebody might say something that's upsetting, but there's an environment of trust that's been created. People might have freestanding relationships beforehand or afterwards. That positive emotion is really important. I'd be curious, how people would set up the room, whether it's at the beach and there's like a little barbecue with vegan options, or what's going to happen. In academic research, by the way, it's kind of interesting. Merely having a pleasant scent in the room is associated with people reaching faster and more creative agreements. Also, if you go into Williams-Sonoma at the holidays, you wonder why they have these strong scents there. People spend more money when there are strong scents, right? And part of the mediator's task, I think, is what I call the candy lesson. So most of us like chocolate, but some of us like dark chocolate. Some of us get migraines from chocolate. So the mediator might try to set up a pleasant environment, like say a joke that actually offends or excludes some people. So I think that's a really important skill of the mediator, is reading the room. And second and last thing I'll say here is reading the room continuously for the emotion, positive and negative. The Dalai Lama uses this great phrase, the spark before the flame, right? And one of the things that I've taught to jams and others is recognizing what is that expression in the face that tells you, here's one of them, a half smile like that, that's kind of exaggerated, like that, is contempt. And that's one of the worst predictors, or I should say it's a predictor of a bad outcome in a marriage. So that's one of the things that I think mediators can learn, and all of us can learn in our negotiations in everyday life, is how to both build the positive emotion and also to keep track of the negative emotion that may be brewing before it explodes.
Angela, let's bring you in. What is your thinking on this?
So one, thank you all for having me. It's such a pleasure. I'm just sitting here learning from everyone. So I'm excited like a kid in a candy store here. But I'm probably like somewhat of an outsider to the I've done some work in the entertainment industry, but certainly not the experience that Joel and Greg and Professor Ulrich have, and all of you have, of like literally being in that room during negotiations. And as an outsider, I'm thinking that language is super important. So I appreciate that we named this panel, can mediators help with the process versus can negotiators? Because I think that literally goes to the heart part of why we're having this conversation. As Greg so eloquently outlined, mediators come in with this, attitude of, I'm here to facilitate, I'm here to help the parties come together, to collaborate, to figure out where the gaps are in communication and how you're seeing things. Whereas negotiations, which that seems to be what Hollywood is driven by, as well as the entire unionized industry, is all focused on negotiations, which means everyone, even in a great environment like Professor Clark is describing, everyone's coming in sort of with blazing saddles and, ready to kind of hold fast to their position. So the most important thing I think a true mediator or true neutral could do in a situation like this is help to create the type of environment that Professor Freshman is speaking of, but also be that person in the room that helps the parties to sort of move off of their hardcore beliefs and strategies about negotiating. And I'm wondering if there's anyone in the room playing that role, because if not, it's and we see it every day in our mediations that, people hold fast to their positions and their beliefs and their thoughts. And you need someone to help break through that impasse. So I think Hollywood needs mediators, because for hundreds of years it's been focused on negotiations, and it's great. They ultimately get the deal done. Unions ultimately get their collective bargaining agreements updated, but it could probably be done a lot faster, with a lot more creativity, and possibly a lot more fun if you sort of had that person in the room that's playing that role of neutral.
Now that's a good transition to discussing briefly the recent history of entertainment labor mediation. And
so before you do that, maybe what you can start with is that positivity in the room, and whoever mediates or is an intermediary for this, remember COVID, they came together, all parties, all guilds, all below the line, above the line, and the AMPTP, they worked tirelessly and they got the deal done. So maybe start with that. Don't start with where they're differing. Start, Jonathan, remember where they came together and how they were one of the first in the world to get back to work during COVID and to create those guidelines, and start with that.
That's an important point. The return to work negotiations, which included basically all the guilds except the Writers Guild, actually, was a unique experience in Hollywood, in that the unions had, and the studios had to reach a set of protocols for doing filming in the face of a pandemic, and the protocols for actors, for crew, for directors all had to be congruent with each other. They had to be consistent and the same. And so the unions negotiated jointly with the AMPTP, as Pam is mentioning, and amended their respective collective bargaining agreements concurrently. That was the first time in the history of the Hollywood unions that this has happened, and that would be a very interesting place to, in setting for a mediator to set the tone in the room, to remind the parties of what they were able to accomplish in the face of COVID, and that the industry is facing with all the changes in the industry. The box office is down, linear television, broadcast and cable are dying, building streaming platforms to compete with Netflix is incredibly expensive. Money is hard to get these days. Netflix had a lot of advantages, to remind the parties that they're now facing something existential, just as they were 2-3 years ago with COVID, and they conquered that. So let's use that as a jumping off point. So Pam, I think that's a very good point. The history of mediation in the industry has not been very mediation for entertainment labor has not been very positive, but it involves federal mediators. So there's an organization or an agency called the Federal Mediation and Conciliation Service, federal government agency, obviously. 15 years ago, mediators were brought in for the writers' strike. They or a mediator, at least, he was unable to make progress. And then for the ensuing SAG stalemate, Screen Actors Guild worked for a year without a contract. They didn't strike, but they didn't reach a deal for close to a year. Mediator was brought in for that. Again, was not able to gain any traction. And then the studios in the SAG-AFTRA negotiations last month or earlier this month, whatever it is now, it's a little earlier this month, I guess, suggested calling in the mediators on the last day of the contract was already extended, and the union agreed but wasn't going to agree to an extension. So why did mediation fail 15 years ago? I think, and the panelists can jump in, that for someone who's not familiar with the industry and with the collective bargaining agreements in this industry in textured detail, it's very, very hard. The issues are complicated. These collective bargaining agreements run to 600, 700, 800 pages, unlike union agreements in other industries that are typically 50 to 100 pages. There's just an awful lot of detail and history to it. I mean, people have long memories. The contracts have clauses that date back, in some cases, close to 80 years. And to expect someone who doesn't have the expertise and the experience with the unions, unlike many of the panelists here, and unlike some of the other people who are working to be intermediaries, is just very difficult. I don't know if the panelists have and then the latest, of course, in addition to just have one day, 24 hours, you're not going to do anything in 24 hours. It was ridiculous. Joel, did you want to jump in?
I just wanted to say that to bring in someone from the FMCS who doesn't know the business, doesn't know the collective bargaining agreements, and doesn't know the history is probably not going to be very useful. But I think there are people in the entertainment industry, whether it's us mediators or other people, talent, lawyers, and they know the history. And just to give one example of a really, really important issue in both of these strikes has to do with AI and what can AI do? Can AI take the place of a writer? Can AI take the place of a performer, either a lead performer or a background performer? And I think it's important to note that there's a long history of technology changes in this industry. The way movies get made today is nothing like they got made 20 years ago and certainly 50 years ago. And yet, even though every single collective bargaining agreement that I'm familiar with, or negotiation, I should say, involved a question of new technology, which potentially would take away jobs. The fact of the matter is, all of those negotiations ended successfully, maybe sometimes with a strike, but somebody who knows the history of how unions can adapt and studios can adapt to new technology, that's going to be a big leg up. Just like Pam mentioned, well, they all got together on COVID, right? So maybe they can get together and say, this is not the first time we've had brand new technology and we don't exactly know how people should get paid or how people should work or how many jobs are going to be taken away. But when you know that history, when you know that many, many deals have been made in terms of brand new technology, then you have a sense that you can say, we have done it before, we have done it with other challenges, the internet being one really big challenge a number of years ago. And so we have the capability, if we really bargain together in good faith, to see that we can take care of the AI problems, and they are significant. No reason to belittle them. They are huge problems. But at the same time, thinking back on the history of all the different kinds of technological changes that have happened, the parties can say, well, we have done that before and we can do it again. And you need an intermediary to remind them of that, remind them of how they resolved this in the past and the fact that they could resolve it again today.
Yeah, and to put the complexity in context, the number of lawyers in the country, and most entertainment lawyers don't understand the guild agreements in any detail. If the number of lawyers in the country who do, if you leave out lawyers who are in-house at the studios and the MPTP, those who are in-house at the guilds, the panel of arbitrators, such as yourself, is a dozen or 2 dozen. I mean, it's literally that small a group of people who really understand these agreements. They're that complicated. And when you look at, and there are relationships between the guild agreements, pattern bargaining, so things that are given to one guild, often another guild or union will demand a parallel provision. And if you make a movie or TV show under the jurisdiction of the three above the line unions, plus the IA and Teamsters, you're talking over 2,000 pages of union agreements. It's just, it's almost incomprehensible. Yeah, Greg.
Let me tell you the challenge that I think is faced here by who can help, right? And I don't want to jump too far ahead in your outline. And I know that Pamela has strong feelings about this, but I don't think ultimately any of us are going to disagree about this subject. I totally agree with what Joel just said. And I think we all agree that it is incredibly useful to have someone here be the facilitator, help in facilitating the dialogue, who has substantive knowledge, precisely because of what Pamela began with. The list of attributes includes creativity, it includes persistence and patience, integrity, trust. The stakeholders need to believe that the person helping them facilitate the conversation has some understanding, shares a common vocabulary, can help them with the creativity. One of the problems is, and I'm not advocating that mediators need to be the person to help here, you can have the smartest lawyers who understand the agreements, the technology and everything else, who are terrible listeners, right? Who don't have the capacity. I often sit with litigators and they talk about what their next act may be, right? What am I going to do when I think about retiring? And they say, God forbid anybody would want me to be a mediator because I can't keep my mouth shut, right? I don't know how to listen. I don't know how to stop from trying to interpose a solution on parties. When I first started doing this, I read the briefs from the parties and I thought, okay, I know the solution to this. I can be the smartest guy in the room. And it took me about 35 seconds when the mediation actually began to realize I knew a bat squeak compared to what the participants knew, right? No matter how much I thought I knew. There was a lot of information I didn't know, a lot of the motivations and true interests that I didn't understand. And only when you worked with parties to try to understand the real motivations, the real interests, and try to bring them together collectively to find a solution and have that patience and have that perseverance and keep them at the bargaining, do you help them find their own solution to the problem? And that is a skill that a lot of lawyers have and a lot of industry executives may have, but it is not something that is universal. And the fact that somebody has industry knowledge doesn't mean they can solve the problem. Now, that doesn't mean you have to be a mediator. I mean, George Mitchell, the former Senate Majority Leader, could be, wound up being a great negotiator and helping with the accords in Northern Ireland, right? He did what many people thought was miraculous in helping people overcome emotions and find their path to a solution. You don't have to be a formal mediator and have that training, but you do have to have certain skills to help people get to the table and find their own path to the resolution.
Clark or Angela? Clark?
I largely agree with Greg that it's important to have the parties advocate for themselves rather than to suggest a solution. I think that's often super helpful. And I think at some points, there is a role for the mediator in suggesting alternatives, right? Because we know from, again, sort of like wearing my professor hat, there's a fancy word for this they developed and somebody got tenure on, which is called reactive devaluation, which essentially is in the common phrase, consider the source, right? So if Netflix proposes directly, hey, here's how we see the solution to the AI problem, a whole bunch of people seemingly on the same side, some on the other sides, are going to be skeptical of it. So at a certain point, I agree with you, Greg, you have to figure out what are the true motivations, what is the true information that's there, what's truly acceptable to people. And then at a certain point, someone, whether it's the intermediary like George Mitchell or someone else, or the way that Jimmy Carter mediated the Middle East peace accords, or Clinton did with other Middle East peace accords, someone has to suggest, who's not a direct party, well, maybe this is a way that we could do it. I'm curious what other people think about that and when they think that should happen here.
Can I just say something about that, Jonathan? Because I don't disagree at all with what Clark said. But, you know, in terms of reactive evaluation, for example, one of the things that mediators do, sometimes they create and float options. Other times they float options from a party as their own in order to avoid the reactive evaluation problem, right? You know, but reframing is often what a mediator will do, right? So take streaming as an example, right? Streaming is a way to do profit sharing. It's about money, and it's about finding a path to an equitable distribution of money. It's a way to help understand the parties need to understand what the economic interests are and the economic motivations, and to try to get to a sharing of data. And there's a real reluctance to share data here. Now, it's not like that doesn't happen within the industry in certain contexts, right? In the music industry, you've got BMI and ASCAP and CSAC that, you know, that collect royalty information, distribute royalties, collect the data from, you know, from the music companies. There are models for some of the royalty distribution. It's not I'm not suggesting that's the model here with regard to streaming streaming residuals, but there are ways, if you understand certain parts of the industry. I mean, there are profit participation statements and audit rights and things that don't fit all aspects of the you know, of the distribution of residuals on every level, because not everyone's a profit participant. But there are conversations to be had. You just have to hear everybody out and understand it's not a straight distributive bargain. It's not a zero sum between, you know, between 2% and 5% and 11% to come to a decision about residuals. The world of how people's interests in residuals, those interests have changed from the linear model to the streaming model in a way that there, you know, ought to be a reimagining of that at some level. It may not happen in the first 3 years of the next contract, but there are conversations among people who are willing to have that conversation to create a little bit more symmetrical information sharing that could happen around a table.
Angela, did you want to jump in? Have any thoughts on this?
No, I think they've covered that.
Great. Okay. Well, that, you know, let's talk.
Jonathan,
Go ahead.
I love about this new reactive devaluation and holding space, which is listening, like Greg said. I think it's important. Herb Cohen, who is a great negotiator, when he was teaching his son how to play games, things that aren't on the board, you have to be creative. In this case, Barry Diller was talking about the salaries, if we're going to call, of the top performers in Hollywood and on the sides of the studios. So if we're going to be creative, is there a way that they would agree to reduce their salaries in some way and then have that maybe go to a fund that would pay for the others, actors who couldn't make the $26,000 for the pension and health to be funded? Or AI, for example, background, could they agree they'll get $500 for the use of their image to AI, but then the studio will pay for pension and health. They will qualify them for the next 10 years. The creativity and thinking outside the box is another issue that I think that anyone has to bring in.
Right. No, that's a good point.
Yeah, and I raised the question about, you know, the relative balance of being an insider versus an outsider, and inside of what, right? So when we're talking about AI, it might, in terms of the guilds, Jonathan's totally right. So for somebody to understand all of the agreements and all of their interrelationships, definitely there needs to be someone who has some intermediary mediator role who's paying attention to that. And there might be on other issues such as AI, maybe the relevant expertise is not just in this industry, but in other industries such as gaming, or even very different industries such as journalism, where somebody might be able to think, wow, here's this creative solution people found with this gaming company. Maybe we can do something like that.
Right. And that is a good transition to, let's talk a bit about how mediation works. And the first issue that we want to raise is we've been talking about the mediator. Who can be a mediator in this context? There are political figures have weighed in. Governor Newsom, Mayor Bass have both indicated an interest in playing a role. Entertainment attorneys, entertainment executives, historically Lou Wasserman, who was an agent who then became the head of Universal for many decades, was of course on the company side, but also was a labor power broker. There really isn't a Lou Wasserman type figure right now. The heads of the talent agencies, Brian Lord of CAA was on the picket line, the SAG-AFTRA picket line a couple days last week. But Brian, Ari Emanuel of Endeavor, and Jeremy Zimmer, UTA, are people who have been mentioned. Angela, why don't you kick it off for us and talk a little bit about the pros and cons of these different kinds of figures, the politicians, the lawyers, the insiders, serving as mediators or intermediaries, as the case may be.
Right. Well, I would not call them mediators, right? Because mediators are, especially trained or professional mediators. But I think it's an interesting conversation because it seems to go to like this deeper societal issue that we have of needing a savior, right? Like, unless, someone comes in, if name recognition, ID, et cetera, comes in and saves the day, perhaps there's not as much respect for those on the ground who are engaged in the process. But it works, Mayor Bass, who I consider a very good friend, with the LAUSD strikes, I kind of reached out to LAUSD. It's like, you all need a mediator. Let someone come in. Reached out to Mayor Bass. Like, you need somebody on your side to like be there at the table, because you're coming in to make a deal. You're not necessarily coming in to do all the facilitative work to get to a deal. And people, and there's the pros and cons of that, because you got the deal done, right? But I think it goes to sort of some type of mental, infatuation that we have with saviors and individuals of name kind of coming in and saving the day, and that has its value. But presumably the mayor, the governor, et cetera, they're busy governing and running the state and running the city. So can they be there on the ground every day, getting things positioned and covering all the bases? Maybe they come in at the end where there's 2 or 3 remaining issues and they just need someone to say, hey, y'all, get this done so we can get the city moving back, get Hollywood moving back. So I think there's a value, but I think it goes to a deeper issue that we have of feeling like we need a savior when we really, for the most part, can resolve our own issues with the professionals at the table.
Maybe they come in at the end, or maybe they come in at the beginning to get the parties to actually get back to the table. Greg, did you want to comment on this?
I've kind of talked about it before, that there are you don't have to be a professional mediator, I think, if you have the respect and the capacity to help resolve it. The bigger issue for me is whether you meet the criteria to bring not just the substantive knowledge that I think is important to help with the creativity here, but also the skill to, have the trust and the credibility to mediate this dispute. One of the important parts of this, and I think we'll probably talk about this later, is to create the architecture of a mediation here. As you implied earlier, these disputes are not going to get settled by somebody sitting at the head of a table with 100 people in a room, right? There are multiple stakeholders and multiple stakeholders within each side. So there needs to be an architecture created for communication with the various stakeholders to make sure, you imply there's unity. Well, it's not uncommon for mediators to have to mediate within each group of stakeholders, right? There has to be a process designed, and somebody, with a certain level of skill has to be engaged in a conversation, not just kind of drop in and say, I am here to settle your dispute. That just doesn't happen in a dispute like this, right? So I think we'll talk a little bit about timing. I don't know if you want to transition into that at some point soon, but in terms of who can do it, I think we've kind of touched on that conversation already.
Yeah, so let's talk about
Jonathan,
go
I
ahead.
have a comment with respect to the governor and the mayor. With all due respect, I think we have a homeless crisis, and that's another huge issue, in addition to what this is going to become an economic crisis. But in my humble opinion, when I look at them and how have they succeeded in addressing this issue that's primary to them. So before I would bring them in, I would see what is their success record and what are their capacity, like how are they working on these other issues. So in my humble opinion, I'd rather see them solve that issue first, which is, and I think there are other people, but I'm actually changing my mind in this because I think the mediators actually, you may have more capacity and training maybe, and incense and lavender to bring into the room to do this. So.
No, it's a good comment. Joel, did you want to?
I want to talk a little bit about the timing. When should somebody come in to try to help the parties figure things out? And just to use the model of a mediation, I think we mediators know that if at the beginning of the day we say, well, I've read all the briefs, I know what this case is about, so I'm going to make a mediator's proposal that the parties settle at a certain number, or the parties settle on to do a certain thing. And that's a ridiculous thing for a mediator to do. But there is a time when a mediator should make a mediator's proposal, and this has to be when the parties have exhausted their attempts to reach an agreement without the intervention of the mediator. So the mediator can work all day long trying to facilitate a settlement, and sometimes the mediator has to say, this ain't going to happen unless I step in and I say, I am making a mediator's proposal and this should be the result. And you don't do that unless you feel out each side and have a sense that there's a good chance that both sides are going to accept your mediator's proposal. And I think most of us mediators have a pretty high percentage of settlement when we make a mediator's proposal, as long as we're careful and we listen to the parties all day long and we more or less tell them what we're looking for as a mediator's proposal. So I think this strike has certainly, from the writer's point of view, gone on long enough. It's certainly from the actor's standpoint, maybe has a little while to go, but I think at a certain point, someone is going to have to say, okay, you have tried back and forth negotiations. They have failed. And this person should be able to have some what if questions to say to the chief negotiator for the studios, what if I could go into the other room and get him to agree to X, Y, and Z? If I was able to do that, would you then agree to A, B, and C? And that can be very, very helpful, these what if questions, which only a neutral person can ask. If it comes from the union or it comes from the AMPTP, it's not going to be looked at as a good proposal. And then the more you go back and forth with your what if questions, maybe you are building up to some kind of a glorious mediator's proposal that has to be worked out, and the language has to be worked out, but that the parties can accept, giving up here, getting something there. And that's what a mediator, an intervener somehow can accomplish.
So there are two things implicit in what you just said that I think are interesting. One is the working towards a proposal, the concept of building momentum in the mediation, and presumably starting with starting with, as Pam said, where the parties agreed in the past, but then starting with issues that may be easier to negotiate, to mediate, than and working, building on success, and that gets that and not getting ahead of your skis, as in a mediated proposal, as you mentioned, I think also implies that one thing that's important is that the mediator maintain or retain, I should say, the confidence of the parties. That if the mediator is seen as, obviously, if the mediator, as folks have said before, is seen as favoring one side or another, that's problematic. But the other thing that's problematic is if the mediator is seen as making a proposal that both sides view as unrealistic, then it's like, well, this person doesn't really get it. I don't know how they're going to mediate things. I don't know if Clark, you were nodding, if you want to.
Yeah, I mean, I think Joel's approach is definitely one way of doing it. It's a very helpful approach, which is to wait until the end to propose a mediator's proposal. There's a certain magic to doing that. There's also the possibility, which Greg referred to, of saying like, well, the other side is suggesting this, right? I've heard, not even attributed to the other side. I've heard some people suggesting this. Hey, did you read this article that Pamela wrote in the USC Law Journal? What do you think of this idea, right? One way of getting at what people's interests are, because sometimes people don't know, is to give them a proposal and say why or why not. And that will help you in this process that Joel is describing of coming up with the ultimate mediator's proposal.
Let's move on to what drives, we've been talking about timing a bit. Let's talk about it from a slightly different aspect. What drives a deal? Sometimes there's a pressing deadline. The 2008 Oscars was one of the key factors that ended the writer's strike 15 years ago. There don't seem to be pressing deadlines in our current context, except maybe the Oscars, which would turn into a 250-day strike, God forbid. Monetary pain that increases incrementally for each side. Stakeholder pressure, the union members, the company executives saying, let's get this done. Outside pressure, the general public, Wall Street, and personal relationships. Greg, maybe you want to talk a little bit about, in that context, what makes a deal fertile? What makes the ground fertile for a deal?
I don't want to get too existential in answering that question, Jonathan, but one thing that strikes me here, the list, again, I want to go back. Pamela began, with this list that was terrific. I mean, it was just a very philosophically sound, cooperative list of things that if two sides would share these attributes, you'd get a deal done, right? But what is actually happening is you have two sides that aren't talking to each other at all, right? What is actually happening is very aggressive language hurled from one side to the other, right? And that is reflective, unfortunately, of what's happening in society in terms of civil discourse. It makes it very difficult to engage in conversation. Now, I would like to say that in the civil litigation in which Angela, Joel, and I engage, that doesn't happen, but truthfully it does. And there's been a coarsening of that discourse, in the years that we've been doing this. Classically, the literature that, Clark is going to nod when I say this, the interest-based negotiation literature says, be hard on the problem and soft on the people, right? If you got a problem in terms of how you're being treated on residuals, on the guarantee of your room in mini rooms, in your fear of the security of your job in AI, all of those issues, be hard on those problems, but don't abuse the people on the other side unless and until there's a reason to do that, right? So we're having a problem getting people in the room to even talk to each other. And what you're suggesting is that there, may come a time where there are external forces that will leave people no alternative because their houses may be foreclosed. But then there are actors, saying, I'm going to contribute $1 million to the strike fund, go get them, that make it, harder and more problematic to get to the table. I come from the school where there's never been any problem that is so difficult that I wouldn't sit down and talk to somebody about it, right?
Well, there's such a kumbaya aspect to it. Let me ask a hard question, which is, the parties are really angry at each other. They both feel disrespected. They're pissed off. How do you and anyone jump in, whether Greg or Angela or anyone else, Clark, Joel, Pam, how do you get the parties to be less angry so that they can, as seemingly a precondition, so they can then start to talk?
Jonathan, if I can, Greg, those attributes came from Carol Lombardini, not me. Just to clarify for the record.
No, I get that. And that was what was so compelling about them.
Number two, I think if they can say we are victims of AI, what is AI's goal? Divisiveness. They are AI and the bots, robots and all that are dividing people. So they're only talking to their own sectors. AI, my question, has our society become so divisive, vitriolic, and hard on the people, right? Instead of soft on the issues, hard on the problem. Are we buying in? Has AI affected not just these negotiations, but our whole life? And this is a result of the AI using how we are dividing people based on what they're watching.
But go back to Joel's point, which is that from the beginning of the industry, technology has evolved, right? John Rockefeller created an assembly line, to mass produce automobiles, right?
Ford, rather, Henry Ford.
Right. Technology is constantly evolving. The issue is, are we going to control it? And Clark can weigh in on this, but there is social science research about moving from, and this is what good mediators, I think, try to do, moving from kind of what's called system one thinking by Daniel Kahneman, which is what most of us do, right? We make impulsive decisions, we make emotional decisions, to more rational based, decisions, right? So for example, in a classic mediation, we might sit and listen to what somebody is thinking and what somebody is feeling, and listen to their story, but also try to engage in kind of a cost benefit decision tree analysis in a classic litigation, to have them think about what makes rational sense for resolving a dispute, right? Here, if you break down, as an example in terms of your momentum building, resolving residuals, whether you're recasting it, whether you're just finding a short-term solution and a zero-sum kind of distributive analysis of it, and you do the economic analysis, you can do that, put AI aside for a second, look at the economic analysis of streaming, and try to move from an emotional reaction to it to the economic analysis, if you can get your hands on numbers, which is an issue, and make a rational decision, not an emotion-based decision with regard to that. Now, in a skillful context, you can do that.
Joel, did you want to jump in?
Yeah, I just want to say real quick that something I often say in mediation to the parties is, if they're in a lawsuit, I say, and I know that 97% of cases filed in Superior Court are not going to go to trial. At some point, they're going to be settled. You have the choice. We can settle this case now, or $250,000 of discovery expense, then you can settle it. It's up to you. And I think as long as parties understand the tremendous cost of delay of waiting for a settlement, that can be an inspiration to them to settle sooner rather than later. And I think it's also true to say, in the context of collective bargaining, strikes settle. Almost all strikes settle. Once in a blue moon, maybe a strike is so bad it doesn't settle, and the company that's being struck is going to go out of business. But we're not talking about that. There is a history of strikes in the entertainment industry. They can last for 2 weeks, or what was the famous Directors Guild strike that lasted 10 minutes? And then there's strikes that go on for close to a year, but they will settle. So once the parties understand at some point, we're going to have to make a big compromise. We're going to have to give up something we really dearly love. And if both sides can get into the mode of realizing at some point, could be 6 months from now, we would normally reach a compromise. Why can't we do it now and stop the pain for unpaid writers and unpaid actors, and the pain for the studios that don't have any product to put out there, and that's their whole business, is putting out new products. So I think once you realize, and somebody can tell them, you know, it's going to settle at some point, doesn't it make more sense to make those concessions now rather than after all another 6 months of pain?
Yeah, no, the way I put it, and then I'll call you Clark briefly, is that negotiation is not a shopping spree. You don't get everything you want or even everything you necessarily deserve. Clark, why don't you jump briefly, and then we will go. We have just a half hour left. We'll go to some of the issues and talk about how to apply techniques to each of these issues. Go ahead, Clark.
Yeah, sort of 2 points on this. So in terms of what Joel is saying, 100% agree when you've got a small number of finite parties. The problem here is that there's a mourning process that has to take place, which is sort of the second aspect here, right? Is that there are emotional aspects to this. And as Greg was mentioning, System 1 and System 2, that Nobel Prize winner Kahneman had, he doesn't actually say that the sort of rational approach is always the better way. He says that sometimes System 2 is better, sometimes System 1 is better. And part of what mediators do is to see, oh, wow, I've done a lot of these. Automatically, it pops into my mind. I see what the solution could be. And maybe that's right, maybe that's wrong once they test it out with the parties. The difficulty here, and I think part of the emotional issue, is that it's an identity issue that doesn't come up with all technology, right? I have a friend who's a showrunner and longtime writer, and he actually used AI without telling his writer's room to come up with some scenarios and then pitch them to the people as if he had come up with them. And when I talked about why, he said, like, oh my God, if they knew that I was using AI, they wouldn't want to work for me. And even if they wanted to work for me, they'd be so upset that they wouldn't be able to do this. So I think for these 2 reasons, that there's a big group that needs to realize, like, look, we've tried, the representatives have tried. If SAG gives in now, if the Writers Guild gives in now, their members won't ratify it, would be my guess, unlike the situation Joel's coming up with. And 2, there has to be this process of mourning, in a sense, of realizing, wow, there is this change in technology. This really does go to my identity. We're gonna have to try to figure something out with this.
And if I could, Jonathan, just very quickly on this stream of thought, I think what Professor Freshman is saying is true, the mourning process. And I think what mediation allows to happen is where both, as Greg said, both sides are not talking to each other now, is they get to talk to the mediator. So the mediator could literally do a whole day of, let's mourn, let me hear all the things that, you know, you feel the other side's not hearing, but embed in that same conversation, if I'm in with the unions and, you know, their representatives, I'd be listening to them, but also kind of getting them to think about the economics of this, right? Because maybe they're not quite seeing things from the studio's perspective. When I'm in with the studio room, I'm getting them to take off their business hat, letting them mourn and talk about how the unions just don't get it, don't get the economics of this, but also inviting them to kind of take off their business hat and put on their human hat so that they could see, you know, why this is, you know, so hard for, you know, individuals who, you know, feel that they're working hard every day to deliver for their families. But I think that truly is the power of having that neutral person available, because whereas the 2 sides can't talk to each other, you know, the mediator, the neutral, is a listening ear that can help facilitate that dialogue.
Great. A quick interjection. People should check the chat. There's a link to the CLE materials. 200 pages of informational materials, articles, and materials from the guilds and the AMPTP. Greg, did you want to say something or no?
Good.
Okay, great. So let's talk about some of the issues and how our panelists would mediate each of the issues. And let's start with a very traditional economic issue, the increase in basic wage minimums, the scale that a fair number of actors are paid and that a lot of DGA below the line people are paid scale, and many writers increasingly, according to the Writers Guild, are making scale. The DGA agreed, so it's 3-year contract. We'll just talk about the first year, the increase in the first year for the sake of convenience. The DGA, which did a deal without striking, agreed to the studios and DGA agreed to a 5% increase in the first year. The writers' last ask was 6%, and the studio's last counter was 4%. Presumably, they'll settle at 5%, the same as the DGA. SAG-AFTRA, though, initially asked for 15% and is now asking for 11%. The studio's offering 5%. The reason for that, much larger, and typically it's in the past years it's been 2.5% to 3% what they get each year. But we had 7%, then 6.5%, then 5% inflation. So SAG-AFTRA wants a oversized catch-up payment in the first year to account for inflation. As the union put it, we are not going to agree to a deal where our members make less in real dollar terms 3 years from now than they made 3 years ago. The studios are also concerned that next year the IATSE, crew union, and Teamsters contracts expire, and whatever they agree to with SAG-AFTRA would presumably be something that those two below the line unions would be demanding next year as well. So there's the pattern bargaining aspect to it. And query whether if SAG-AFTRA gets something better than 5%, whether the writers would up their ask, who knows? So let me ask one or more of the panelists to jump in and say, and talk a little bit about, how would you mediate this classic economic issue? Do you just split the baby? Is there a principled discussion of inflation? Is there, the studios say they're offering historic increases, but of course inflation was more than historic. So, how do you handle this? Anyone want to help me with that?
Well, I'll jump in that very typically in mediation, we do have only a fight about money. And the first half of a mediation, maybe you argue whether there's liability or not liability, and then you just turn to the money and look for compromises. I think in a case like this, certainly there's a fairly easy or not super complex issue with the writers to come up with it. In terms of SAG, it is not necessarily the studio's fault that there's inflation. Inflation is also coming down rapidly. So I think one of the things that can happen is that some of the money can be backloaded. It may be very difficult to give an 11% in the first year, but a lower percent in the first year, maybe an additional percent in the second, maybe backloaded for an extra 2% in the third year. So these are the kind of things that the parties can be talking about. And I feel like given all the other issues that they have that are going to be much more difficult, these should be, if everyone is acting rationally, things that people can work out.
One of the differences in the way the parties look at the overall packages that I've learned is that the studios, the MPTP, by and large, looks at the total cost of the offer, and Carol and the companies will have a red line in mind as to how much they're willing to the value of the package, the value of the increase, whereas the union is more focused on silo by silo, item by item. What is the principled argument? Here, the principled argument, in their view, the principled argument is inflation catch-up. The studios are like, well, if we add what we are offering plus everything else, it's $1 billion package is what they're contending. I think it actually is probably a bit less, but even $1 billion package works out over 3 years, works out to about 30 million per company per year, which is less than the CEO gets paid and is pretty much chump change if you're spending billions of dollars on content. So there's a head-to-head. Now, Joel, as a former Sony person, you probably have a bit of pushback on that, but go ahead.
I've said enough. I'll let some of the other panelists talk about this.
Sure. Anyone else? How would you approach this? Yeah, Pamela.
Jonathan, I think it's important that the collective bargaining agreement addresses minimum terms and conditions. So that's the bottom level. And I think before about what Barry Diller said about the top earners. So my question is, can a mediator, you can't do this in collective bargaining, but just like some of the SAG guild members wrote a letter saying they support the strike, they're willing to go out, they're the top earners. Can those same top earners agree to set aside, let's say they make over $1 million, 1%, 5%, 10% of their, to create this additional fund? And why do people want to get paid those minimums for the most part? To make pension and health. So to be creative, so set aside fund that's created by the top earners in all talent, the directors, the writers, the Screen Actors Guild, and the studios, and some of the guild employees that are making more than $500,000, for example. Could they give back some to create this fund to help supplement why they need the minimums? Why do they need to make that much money? Most of the actors aren't making $26,000 a year. And what if it pension and
which
health?
is the threshold for qualifying.
Right. It's the
For
threshold
pension.
for qualifying for pension and health. So creativity, when you look at the minimums, I'm curious, is there a way to somehow make the maximums part of this, not through collective bargaining, but maybe a mediator could come up with the suggestion and have people sign on?
My personal opinion is I'm more likely to see $1 under my pillow from the tooth fairy, but I don't know if other people think it's likely. I mean, it is what you're saying, of course, gets the fact that the US economy has increasingly over the last 40, 50 years become a winner take all or winner take most economy. And that's true at the top levels of executives, and it's true at the top levels of stars, and and in various other contexts across the entire economy. And we do have a situation here where some people have accumulate hundreds of billions of dollars in net worth, and others either starve in the streets and sleep on the sidewalks, or the luckier ones have often have 2 to 3 jobs and struggle to put food on the table, keep a roof over their heads, and half the country doesn't have $500 to its name for a medical emergency. So that you are certainly keying into a real issue here. Whether Barry's suggestion is realistic, I'll leave to other people. Does anyone else want to say anything about negotiating this issue?
Can I just address it broadly, Jonathan? Because especially in the interest of time here, I want to go back to this notion of the structure of this negotiation, of this mediation, if you will. I think fundamentally, before there could be a negotiation of this issue or any of the others, whoever is involved in facilitating this conversation, there has to be a discussion, an identification of the stakeholders, a discussion of confidentiality, a discussion of the exchange of information and how that's to be done, and a real focus on what the process of the negotiation is going to be. Mediators love having multiple issues. People may think that's harder, but the more issues there are, the more interplay and exchange there can be. Right.
Right.
And while there is something to be said for reaching agreement to build momentum, it's not always what you want, right? Because sometimes you want the interplay to have trade-offs. And so I think you have to create the environment and the conversation to know who the stakeholders are, have an agreement on confidentiality, get over this big hurdle about creating sufficient information symmetry to have any of these issues negotiating, and then create the environment. There could be co-mediators. You could have subgroups to negotiate each of these topics that we're talking about, AI, streaming, wage increases, and have co-mediators working together that are coordinating with one another, so you know where the interplays might be. There are all kind of unanswered questions here, because this is a very sophisticated group and of negotiators, and some really important topics. We are at a moment with the most creative executives in the country, right? That what they do on both ends of this negotiation, these are incredibly creative, sophisticated people at a threshold dealing with important issues we haven't faced before. Yes, as Joel says, it's true that we faced technological changes before, but you see everywhere in every industry AI as an extremely important issue, right? Those of us who do copyright cases know how many copyright lawsuits have been filed relating to AI in the last month, right?
Right.
And so it's going to affect every aspect. The president met with a group of executives about how to deal with AI. So, maybe there's going to be a comprehensive agreement reached. Maybe these working groups are going to reach an interim agreement for some period of time so everyone can get back to work and then address some of these broader issues. There are all kinds of possibilities here. And I think until people get back to the table, you'll never discuss the architecture. And until you discuss the architecture, I don't think you'll be able to address any of the particular issues. So I'm sorry to short circuit the one discussion, but I wanted to get that.
No, it's good. And to put things in context, this issue of technological displacement is as recent as the last few months with ChatGPT bursting on the scene. And it's as old as 200 years ago, the beginning of the Industrial Revolution, and people being afraid, not without reason, of being displaced by mechanical technology and now information technology. Let's move on to success-based streaming residuals and talk a little bit about how one might mediate that issue. So the issue here is shows made for a streaming platform that stay on a streaming platform, like a Netflix original. The existing formulas were introduced in 2014, improved in 17 and 20. The DGA got significant improvements in foreign streaming residuals in their deal now in 2023, some improvements in domestic. The unions, the other two unions, are likely to accept that as far as it goes. But what the DGA did not even seek was and what the other two unions want is a success overlay. So right now, a successful show like Wednesday pays the same residuals as a flop like, call it Tuesday. The writers and actors want an additional residual, and they've made different proposals. The Writers Guild would be viewership based, based on company data. Companies don't want to share data. SAG-AFTRA wants a 2% revenue share of the platform's revenue divided up among various shows using third-party data like comparative analytics that uses social media as a proxy for popularity. The studios basically say, we don't like third-party data and we ain't giving you ours either. And of course, they also don't want to pay more. It occurs to me the possible solution would be company data released to a trusted intermediary like PwC or a new nonprofit organization. But, there have been a variety of attempts to discuss what to do and come up with something. This is a monetary issue, but it's also a data transparency issue. The companies are, I think, using the pivot to new technology to change norms, because traditional media, you have box office results and you have Nielsen, and there's a lot of transparency. They don't want transparency in the streaming world. Some people think that it's because shows aren't being watched by as many people as you might think, and that would have a deleterious effect on Wall Street's perception these companies, which is already very challenged and negative. Can someone help me out and talk a little bit about how you might bring to bear mediation techniques on this issue? Help.
Go ahead. It's a very, very tough issue because it's a new issue, but I do think it's very helpful that there was a resolution with the Directors Guild, and that's something that can be the start of any discussion. The other thing, and I meant to mention this when we talked about the minimums, is that the guilds understand and the studios understand that this is a gigantic package, and something that may be provided in the minimums may have to take away something from some other place. And that is certainly true here, that this may, whatever gains the guilds may have here may affect the minimums or other parts of the contract, because it is a whole package that we are looking at. That makes it very different from a typical mediation. But at the same time, if there is a model, I'm not saying the parties have to, the other guilds have to follow the Directors Guild, but I think that's very, very useful starting point.
I
Go ahead.
I respectfully disagree. I think the business model the DGA is using is not keeping up with the times. So if I were the mediator, I would get an expert. I would talk to the cutting edge companies that are doing this. Like Jonathan said before, in gaming, in sports, they know the value of streaming, especially sports, because it's live and how much money they get. So I would go to the outsiders who are experts and not look at the DGA agreement respectfully. And I think a mediator, because both sides have different experts, first ask the writers in the Screen Actors Guild, who are your experts, and the AMPTP, who are your experts? You don't want to share them, but, and then go maybe to a third party who is an expert. So I think the mediator's role is going to be to get more information and be creative, get it from sources, like you said, Jonathan, like gaming, that aren't being utilized.
That actually wasn't me, but I forget who it was. So, but thank you. All right, let's we are almost out of time, but we'll go a little bit longer, if whichever panelists are able to go a little longer. We've talked a bunch about AI, so let's talk about one other issue, which is writers and mini rooms. This is a writer-specific issue. So with a 22-episode network series, you would have a writer room that opens before production. They write some scripts, they start production. As they continue to write more scripts, you would, for 22 episodes, you might have 8 or 10 writers in the room. They meet, the showrunner says, Jonathan, I want you to do episode 2 and episode 5, and Jane, you can do episode blah, 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 et cetera. And then they come back, they work out what the arc is going to be, et cetera. Mini rooms, which have become sort of the new normal for a short season, 10 episode, 8 episode series, which is what's typical, of course, on streaming and cable now. They have fewer writers. They open before production begins. They often close before production begins. And there are several issues there for the Writers Guild. One is staffing levels. They want guaranteed staffing such that, for example, their initial ask is that a 10 episode series, you'd have to hire 8 writers, which is, respectfully is absurd, but of course you ask for more than you expect to get. Duration of employment, they want at least some of the writers to continue to be employed into production. And that's both a monetary issue and a career ladder issue, because if you don't get experience doing production rewrites under time pressure, the actor says, these lines aren't working, the scene isn't working, the director's like, get the writer. Okay, you got 2 hours, we'll shoot another scene. You got 2 hours, you got to rewrite this. That's, nerve-wracking, but that's obviously learning. And then likewise in post-production, when you've got, the writer working with the editor says, I'm going to trim back this reaction shot a bit because we want to keep the pace. And the writer's like, no, we got to keep that because that reaction shot pays off in season 3, episode 305, when Jane, the character Jane, whatever, does something unexpected, then readers or audiences rather are going to be like, oh yeah, she had that weird reaction way back in the first season when so-and-so said such and such. And if you don't linger on that a little bit, people aren't going to remember it. So the writer is the keeper of the story. And these kinds of interactions with cast, crew, and directors and editors are necessary for writers to gain skills that allow them to move up the career ladder. So the Guild is very concerned, both from a monetary standpoint and a survival of the profession, sustainability of the profession standpoint, and a career standpoint about mini room staffing. The studio position is, look, you know, sometimes auteurs want to write all the episodes themselves or want to have just one other writer. We can't agree to minimum staffing levels. You know, this is not reasonable. It's like, you know, when it no longer takes 3 people to run the locomotive because of mechanization, we're not going to hire 3 people. Someone help me out. How would you mediate this?
Yeah, well, let me just say here, one solution is you address the objection, which is this can't work for all series. And they say, well, what if we made an exception for a certain percentage of series? How often do you think there are auteurs there? Or you could say that the average staffing levels have to be this, which would meet the writer's demand, but would give studios and streaming the flexibility to vary it in particular circumstances.
All right. So, and then to put that in meta terms, it's again coming up with creative alternatives that look not to the head-to-head, but rather what are the interests and how can you accommodate both sets of interests? Anyone else? Yeah, Pam?
The DGA has a trainee program where they actually apply and then the director kind of helps train them. My question is, could the Writers Guild start a trainee program and then have that be funded, not just by the studios in the AMPTP? So they're going to get paid, they're going to get trained, and they're going to have the people, they're going to be bringing up the people behind them. So that's a question a mediator could ask.
That's a good question and a good suggestion, I think. You know, it goes again to peeling back the onion and asking what are the interests and how can they be addressed creatively. Okay, anyone else on this issue? Yeah. So
my own feeling is that there's definitely an area for a compromise, that I think there should be writers' rooms and there should be some minimum staffing guarantees, because otherwise there's just the whole TV writing enterprise will be only showrunners. I maybe 8 is too many, but this is something that can be, I think, the subject of a back and forth negotiation in terms of a compromise. But I think it's essential that the writing rooms are maintained with whatever number of skilled staffers. Very, very common in other industries too. Like you mentioned, the locomotive, how many people need to run it. But I think if there's nobody who's guaranteed to be in the room, I think we are really going to lose a lot of television creativity.
and that points out that the studios should recognize that some of what the guilds want is actually in the studio's own interest.
Absolutely, absolutely.
If you can't sustain the profession, and that gets to residuals as well, because residuals tide people over between gigs. And if you can't sustain a pool of skilled writers and skilled actors, you know, in general, you can't make a movie with just Tom Hanks and a basketball or soccer ball, whatever it was. I mean, you know, once in a blue moon, but you need somebody, you need the actor who's playing the waiter that there's a gag, and you know, got to hit their marks and not waste time and not waste, you know, and not screw up.
There was an article in the LA Times yesterday about writers during this time looking for other alternatives to utilize their skills. So, you know, once they get to that place of, I have to survive, I have to take care of my family, as you all have commented, you know, they're going to be, you know, looking at other industries where they can take their talents. And I think that would be such a great loss for Hollywood and for all of us that love the shows that they write.
Right. Let's do about 3 minutes on AI and then any closing remarks. So to summarize what's going on with AI, the writers want guardrails that AI cannot write or rewrite scripts, can't be used as source material for scripts, and covered material existing scripts can't be used to train AI. The AMPTP rejected all that, except that they acknowledge that existing language means that AI is not eligible for credit. They offer, other than that, they just offer to meet once a year. SAG-AFTRA wants informed consent of the unions and the performers, both principal performers and background, at the time of use in another project. So you can't, in the initial contract, say, oh yeah, I'm giving you the right, when you're trying to get the job, I'm giving you the right to use my image AI-wise in other projects other than the movie or TV show that you're hiring me for, because that's too much coercive. I want the job, so I'll agree to anything. Instead, it's later on, once I've got the job, that they say, oh, we'd like to reuse you in another movie. It's like, okay, we got to negotiate with me and the union as to whether I agree to that, and if so, what my compensation is for that. They want informed consent for alteration of the performance. Digital replicas can't replace background actors, and the union and the performer have to have informed consent regarding using my performance as training material. The AMPT response is a little hard to parse. Formally, they said they apparently rejected, but in a sidebar that they did not put in writing, they appear to have agreed to some of this, but it's not, the union does not believe that the union believes there's a gap, and it's not exactly clear what the gap is. So, in terms of mediating this, part of this is to get the studios on the record as to what it is that they're actually offering and determine what the gap is. But the larger issue then becomes, there's fear, uncertainty, and doubt. How imminent is the threat? What do you do about it? The studios are hiring AI people. One of the studios is paying $900,000 for an AI manager. This is poured gasoline on the fire. The studios don't want to be stuck in today's technology when everyone else can use AI. The guilds don't want to be displaced and replaced. How do we mediate this very difficult and uncertain issue?
Well, you can see none of us has a really good answer for this.
Well, I agree. Oh, I'm sorry, Joel, go ahead.
No, you go ahead, Angela.
No, I was just going to say, I agree generally with the thought that's been advanced today, that bringing in experts in this industry, and I'm sure, as I think Professor Ulich said, that each of the players here have their own experts and are consulting with them independently, but kind of bring in a neutral set of experts that can help everyone have a dialogue about it. And also, to Professor Ulich's point, kind of recognizing that AI, and I mean, we're all having this conversation in our respective industries, that it, is a potential threat to us all. And we're all sort of now in the Lord of Flies mode of like, how do we survive? How do we survive? Is it, so sort of getting everyone to the table to acknowledge that, right? That is this a divisive, potentially great tool, but also potentially divisive tool, and kind of figuring out how we can make it a win-win for all sides.
Pam, thank you.
I think
I like what I saw.
Great.
Sorry, I like what I saw in the Writers Guild picket line. AI does not have a soul, SOUL. And I think that kind of reasoning, and when you look at both sides, the AMPTP are humans, right? And so are the guilds. So I think whatever mediator, intermediary comes, they have to remind people that AI, and as many experts, who they are, have said it could destroy the human race. Now, I'm not saying it will or it won't, but a lot of experts are worried. So I think if both parties can see the AI as a potential soulless issue, and how can they come at it together, I think that's how you're going to solve this issue, because AMPTP can be replaced too, right? I mean, at the end of the day, all those people, AI can replace everybody. So I think to come together and look at AI as dividing us, as not being soulful, as a common enemy, if the mediator can do that, I think that would help.
Maybe AI will be a mediator. Greg, you wanted to jump in.
Well, it's funny because there's a lot of talk in the mediation community about exactly that issue, about whether mediators can be replaced by AI. And the answer to that, ironically, is that certainly now the technology isn't there to deal with the human emotions and to deal with the creativity in the human interactions. Some of us are old enough to have grown up in that, 2001 Space Odyssey era, right, of HAL taking over. And Angela was just touching on the win-win, aspect of, most of us who are mediators kind of abhor a couple of concepts. One is that there is such a thing as impasse, right? We reject that notion and believe that impasse is a fallacy, right? The second is that a good settlement is one where everybody feels a little bit of pain and feels they've lost a little bit, right? Most of us subscribe to what Angela ended with, which is how do you expand the pie and get to the win-win? And so the mentality of entering the conversation of trying to reframe the conversation so it isn't this soulless thing is gonna kill both sides, to rather how do we make this technology, as Joel has said earlier, we've dealt with changes in technology forever. How do we take this technology and make it work for all of us to the benefit of all of us? Let's make sure that there is a transparent conversation. It's what we've been talking about throughout this entire conversation, the power of mediation in an appropriate, skillful context. And that's why I keep talking about process. I'm just really concerned about the extent to which we focus on the end result rather than focusing on how we get to the end result. Because when Clark talked about what felt like kumbaya, but isn't really, and that is, when you serve good food, when you do all the things that make people focus on each other as human beings, and it's not really about thinking kumbaya. None of us are kumbaya mediators. We're realistic about the fact that there are human beings involved here on both sides. Corporations are made up of human beings, certainly the unions and those who they represent. So it's all a process about communication and recognizing it. And that's why I haven't been very vocal about the individual answers to the 4 areas, Jonathan. I'm much more concerned about how to structure the process. We've talked about neutrals a few times. I don't actually use the word neutral because I don't like the idea of the mediators kind of putting forward the ideas as much unless they have to become actively involved. A friend of mine is fond of saying, we're not neutrals. When you put your car in neutral, it doesn't go anywhere, right? We're impartial, we're objective. We really try to facilitate a result. And I think that's, really kind of the focus here certainly from my perspective. And I suspect that Joel and Angela agree with that as well.
Well, I would say something about the process to follow up on that, which is neutrality, as some people teach it, is active neutrality, where you're sympathetic, you're not passive, you're not neutral. In that sense, you make each party feel as if you're understanding them somewhere along the way. Not that you're cold, but actually that you're equally warm that way. On the specifics of AI, one thing that could be done is certainly to take the common enemy approach. We're all not AI, this threatens all of us. And I think there's some value that might work. Another approach is to say, well, is there anywhere, right? Is there anywhere that we could see that AI would be something we'd accept under any set of conditions, and then work out from that? And if I were advising, the Writers Guild, which I'm not, I would suggest doing something like that, even if it's just a trivial concession to show we're not being unreasonable. We could agree that AI could come up with story ideas so long as no writers are displaced. We could agree that AI would be able to search for consistency across all of the episodes, for example, and seeing if that builds some degree of trust.
and to put it in a sentence, one of the points that you're making is that I think is that you want a mediator who is disinterested but not uninterested. Let's do a lightning round of closing remarks, and then we will wrap. Greg, did you want to say anything?
You know, I think I've shared my thoughts, pretty extensively. The only thing I would do is John Gardner, created Common Cause, famously said that we're continuously faced with a series of great opportunities, brilliantly disguised as insoluble problems. And I think that really, when parties are unwilling to even get at the table and talk to each other, I think they should be reminded of the opportunities that are available to face the changing world that is inevitably upon them. And I think we're at one of those moments, and I really would encourage people to sit and talk.
This is the most dramatic change in a short period of time since the end of World War II. A third of the country went to the movies every week in 1946. Then television came out of a deep freeze, and also people moved from the cities to the suburbs, away from the cinema palaces, and cinema going cratered. And that led to a 12-year stalemate that then led to the 1960 dual strikes over residuals. So, everything else in between, color TV, cable, home video, et cetera, more or less pales in comparison to what we're dealing with now. Clark, do you want have any closing thoughts?
Yeah, I think this is not a single negotiation with a single mediation process. To go to Greg's point, it's not something that everybody has to agree to. When we ask about what are the contributions to mediators to solving this, it could be that there are mediators who work just with one side or parts of one side to see where they can get some movement. It could be that there needs to be some process with the talent guilds so that people are aware and not sort of shocked by what the final outcome is going to be, that they feel as if they're being respected in some way.
Great. Joel?
Yeah, I feel at the end of every mediation, as Greg was intimating, both sides feel like they lost something, but at least they have a settlement and the entire controversy is in the rearview mirror. So I certainly hope that both sides are thinking now, not how long can we stay out or how much more can we afford, but when can we make a deal, and why not make a deal sooner rather than later? We won't like everything. The other side won't like everything, but a deal is, I think, an opportunity. AI is a very, very difficult topic. We don't really understand how much and how far it can go. And maybe one answer to that is to simply freeze the contract where it is right now with these kind of uses, and then establish a committee that will explore this for the next 3 years, and then maybe consider changes in 3 years, but freeze that for right now. That's the kind of thing that I think a neutral can help suggest to people. And thanks very much for inviting me onto the panel.
Sure. Apropos of that, the writers are concerned that these contracts in many ways are like roach motels. Contract clauses check in, but they don't check out often. The home video residuals formula established in the 80s was reflective of the high cost of goods for making video cassettes. As that cost declined and then plummeted with discs, the formula to this day has never changed, and the guilds feel like fool me once, fool me twice. Angela, any closing thoughts?
Just thank you again for this opportunity to Beverly Hills Bar Association. And I would say to Hollywood, we need you as our shows start to run out this, that we love, hoping that you all will come together because we love you, you're creative, and you are a big part of what makes our society work. And I would just encourage Hollywood and just unionized environments in general to be open. I know you have your years and years in traditions and collective bargaining and traditional negotiations, but I think this is also an opportunity to consider new ways of coming to the table, having a meeting of the minds, whether that's a mediator, a neutral, an impartial person to help out. I do think we could play a role in helping Hollywood to be more creative about problem solving.
Great. And Pamela? You're muted.
I want to thank everybody. I guess my final takeaways are: get off the beach. AMPTP and the guilds, you're at the beach like the Barbie movie. this could lead, like Jonathan said, to the next economic crisis, not just here, the whole world is watching. And the divisiveness that we're seeing can spread like a cancer, not just to Hollywood, but to the whole world. You have to get together, whether it's a mediator or an intermediary, somebody, and all of us have to get together. And I like the soulful idea, come together to figure this out before it's too late, because it is going to affect everyone, the restaurant owners, the people can't afford mortgage, the writers who are going to be losing their homes, the actors who have 5, 10 kids, God bless them. So it has to stop. They have to agree, I think what Joel said, maybe AI for now is a common enemy. We have to have a committee study it, but in the meantime, it freezes. And that gets me to the old collective bargaining agreements. I asked for one recently from SAG-AFTRA because when I left, it's about this thick. They haven't even printed one, Jonathan, since 2014.
Right.
So let's face it, maybe it's time to just get rid of the old collective bargaining agreement and keep it simple and start with a brand new agreement that's transparent, that people working on both sides can get, because my students who are learning about these guild agreements can't even get copies of them. They can't find the provisions online. So maybe, like Angela said, have this be an opportunity to start fresh and to be transparent and an easily digestible agreement. So forget about the cockroach hotel, Jonathan. Maybe use this as an opportunity to start fresh with a whole new collective bargaining agreement.
That certainly would be an ideal. The agreements and the MOAs that update from 2014 onward actually are available online in PDF from all the guilds, but that's only half the battle. The other half the battle is actually comprehending them, and that's not easy. I want to thank the panelists who have just done a stellar job, I think, in bringing both mediation, the concepts of mediation and the application of mediation to these strikes to bear. I'm really very pleased with the way the panel went. I hope that that the panelists are and that you, the audience, are. I want to also thank Randy Benman, the Secretary of the Entertainment Laws section of the Beverly Hills Bar, and Dana Kluchnikov, who is the Beverly Hills Bar Operations Director. Both of them were key and instrumental in bringing this together and in asking me to do it in the first place. I want to wish, obviously, good luck to all of us and all of us in the industry. You can, the audience can feel free to subscribe to my Substack newsletter at jhandel.news, and you can reach out to me at jh@jhandel.com. Again, thank you very much for joining us. For those people, those of your friends who were not able to join, this was also live streamed on YouTube and is available or will be available on YouTube on the Beverly Hills Bar channel or replay at any time. Thank you very much.
Thank you, Jonathan.
Thank you, Jonathan.